Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of Indian Evidence Act, we were focusing on chapter 10, which is all about examination of witness, covered between section 135 to 166. And in that series, this is my sixth video where we are going to focus on section 144, which is all about evidence as to matters in writing. When learning Evidence Act, by understanding one section, you cannot understand everything. Every section is interlinked. Like for example, while learning section 144, you need to have very clear understanding as to what is section 91, what is section 92, what are documents under section 3, and what are primary and secondary evidences, what is oral evidence, and why oral evidence need to be direct, the rule for oral evidence. All of that to be known when you are understanding section 144. That is why it becomes very important to understand the law as a whole when it comes to law of evidence or Evidence Act. Now what I have done, I have explained section 144 in 2 slides, and then I have given all other provisions whichever I have said. All those presentations are over. Now I have brought slides from those presentations, and for the purpose of screenshot I am showing all of them. But if you need to understand the concept, you have to go back to the presentations. But here, just for reference, I will give screenshot slides where you can pause and read them again to rememorize. Now that's what I can give here in this presentation. With that, I am taking you to slide number 1. As I said, section 144 discusses about evidence as to matters in writing, and as always, let's first quickly read through the Bare Act provision. It says, any witness may be asked while under examination whether any contract, grant or other disposition of property as to which he is giving evidence was not contained in a document, and if he says that it was, or if he is about to make any statement as to the contents of any document which in the opinion of the court ought to be produced, the adverse party may object to such evidence being given until such document is produced, or until facts have been proved which entitle the party who called the witness to give secondary evidence of it. This section looks little lengthy and tricky, but this is a very easy section, and I have made my chart very easily. Imagine there is a case in progress, and here in that particular case an evidence is a document, and court has an opinion that that particular document must be produced as an evidence. Now when court has an opinion that that particular document need to be produced, and a witness is about to give any evidence as to such contract, grant or other disposition of property which are in document form. Now we have discussed this particular aspect while discussing section 91 and 92. Imagine a contract, grant or other disposition of property is in the form of a document, and if a witness is about to give evidence on that orally, or if such witness is making any statement as to the contents of any documents, in that case the adverse party may object such evidence and compel to produce such document to the court, or until the party which has called such witness proves all the facts and gets entitlement to give secondary evidence of it. Why so? Because when there is a document available, the document itself becomes a primary evidence. That's a very important evidence. Now you cannot give oral evidence on the contents of the document because document themselves speak. So that is why when it is in writing, the document need to be produced. And of course, if the original document is not available, then it can go to secondary evidence after proving all the facts which we have discussed under section 62 and 63 as far as primary and secondary evidences are concerned. But basically from section 144, what you need to understand is when a particular thing is in the form of document, it is the document which need to be produced as an evidence rather giving any oral evidence or making any statement on the content of the document. Now, these are the important provisions that you need to understand from this particular section. Now, we have an illustration as well as explanation in my next slide. Let's try understand them. Here we have an explanation which is very beautiful. We need to understand what is document and what are the statement about a document and how documents are seen as an evidence and how the statements made on a document, on that if somebody is giving witness, how that is treated. That is well understood with this particular explanation and illustration. The explanation says, a witness may give oral evidence of statements made by other persons about the contents of documents if such statements are in themselves relevant facts. So what happens here? There is a document. About the document somebody has made a statement and the witness is giving the evidence on that particular statement. Here, if that statement made by the person, if that is relevant fact, in that case, though the document is not there, the statements and the witness will be considered. Now, that is what we need to understand, and for that we have a beautiful illustration here. What happens here? There is a question in front of the court whether A assaulted B. Now, that is the question. And here C is the witness. Now, the question is whether A assaulted B, and in that case C is the witness. Now, C gives an evidence. What does he says? I have heard Mr. A telling to Mr. D that B wrote a letter accusing me of theft and I will be revenged on him. What does Mr. A says to Mr. D? B wrote a letter accusing me of theft and I will be revenged on him. Now, what does that statement gives? That gives the motive for Mr. A to assault Mr. B. Now, here there is a reference of letter by Mr. A while making a statement to Mr. D. Now, that letter is not important. Here, what is important? Mr. A has said to Mr. D that there was a letter where B has accused Mr. A of a theft and A wanted to take a revenge against Mr. B. Now, that is the whole matter. Here, though no other evidence is given about the letter, the statement made by Mr. A about the letter to Mr. D and what Mr. C has heard and directly giving as an evidence to court as oral evidence, now that is valid. That is what we need to understand from the explanation and illustration. I told in the very beginning that you need to read section 144 along with section 91 and 92, and from here onwards I will give screenshot slides for you on section 91, 92 and few other provisions because they are very important. Now, I am not going to explain because I have an independent video on section 91, 92 etc. So please take screenshot. This is the slide on section 92. You can please take the screenshot of this also. We have discussed about the different types of evidence in the very initial classes. We have discussed oral evidence, documentary evidence, what is the rule of direct evidence, what is primary evidence, what is secondary evidence, all of that. Here I am giving the chart again for the purpose of screenshot. This is section 60. The oral evidence must be direct. If somebody has heard that there was a discussion about the document, if he or she has heard, they have to come and directly say to the court. They cannot say that I have heard it from someone else and I am giving the evidence. No, they should have heard it directly. That is what a very important aspect that we need to understand from section 60. They must have seen it directly or heard it directly. Only then oral evidence is considered, which is what discussed under section 60. Please take the screenshot for that. What is a document? By now you must be knowing what is a document. This is what we discussed while discussing section 3. Please take the screenshot if required. We also have discussed the different illustrations while understanding what are documents, and these slides are discussed in detail in my initial classes. Just for screenshot purpose I am giving again. There is a reference of secondary evidence, so you need to understand what are primary and secondary evidences. So I have given section 62 here and section 63 in my next slide. This is also been discussed in detail while discussing section 62, 63 and 61. You can take this screenshot here. And finally, before handing it over to Nishan, this is the last slide. You can take the screenshot, that is section 63, which is on secondary evidence. There is a independent presentation on section 61, 62 and 63 where I have explained these two slides in detail.
Everyone needs help. If I need help,